Welcome back to Good Law, Bad Law. As part of our continuing conversation on this program about what we're seeing in the country taking place as the Black Lives Matter movement continues to grow, demonstrations, protests, and real changes in our society and in our culture in response to very rapid changes taking place. It is not only in the context of an awakening, a reckoning with the legacy of slavery and all that has followed, Jim Crow, segregation, lynching, civil rights movement up to the present, but also as part of this broader conversation, the terrible and violent legacy as to Native Americans in this country. My guest, Ezra Rosser, who teaches Indian law and property law at the Washington College of Law at American University in Washington, D.C., joins me to talk about this, everything from the seemingly not very important but symbolic, such as the end of the Land O'Lakes butter packaging that has the caricature of the American Indian on the cover, to a really far-reaching and somewhat surprising, to me anyway, not to Professor Rosser, opinion in the last days of the Supreme Court this term from Justice Gorsuch, affirming broad property rights on Indian land in what amounts to essentially the eastern half of the state of Oklahoma. So we're talking about what it means to think about Native American people in this country in the context more broadly of what's happening in our politics, in our culture, in our society, and in the law. A fascinating, important conversation, and Ezra is fantastic. I know you're going to enjoy this episode. Everyone, please stay safe. Continue to wear your mask. Let's do everything we can working together to deal with this pandemic. Everybody stay safe. And while you're staying safe, enjoy this episode of Good Law, Bad Law. Well, the state of Oklahoma is having a rough month. First with the president's ill-fated rally, return to the campaign trail in Tulsa, and then news, as many of us expected would come, that that rally, with nobody taking any precautions in light of the coronavirus pandemic, has a couple of weeks later resulted in a surge of cases in Tulsa and the area around Tulsa. And now, in one of the last decisions of the Supreme Court term, a case that really gives a pretty stinging slap to the state in terms of the Indian lands in the state of Oklahoma, in a case called McGirt v. Oklahoma. Well-timed for my conversation, the one we had planned for today, and so I want to welcome my guest, Ezra Rosser, who is a professor of law at American University, Washington College of Law, and has written extensively on Indian law in particular and property rights. Has a book coming out, I'll ask you in a moment when it's coming out, called Exploiting the Fifth World, Navajo Land and Economic Development. And we had planned to talk about reparations, a topic that is gaining a lot of energy in the political discourse of the moment, with the return of mass demonstrations around the country, protests around the world indeed, in the wake of the killing of George Floyd. And included in that broader conversation has been a reinvigorated discussion about the place of Native Americans in this country and indigenous people, and that very disturbing, troubling part of our country's history, and what the law is, how the law and our politics is looking at that part of our history in today's world. So thank you, Ezra, very much for being on Good Law, Bad Law today.
It's great to be here.
I really appreciate it. And again, thank you, Justice Gorsuch, for this opinion. To me, anyway, a surprise, because I think we all have expected that any nominee to the Supreme Court by this president would be one to do cartwheels to avoid going against the president. And yet we've seen many surprises from the Supreme Court over the last few years, from the Chief Justice in particular, I think, but now with this opinion from Justice Gorsuch. And you and I were talking just a bit before we started about how the Native American community had pinned some hopes on Justice Gorsuch when he was elevated to the Supreme Court. Why don't we start by telling us what you meant by that, and then I want to talk a little bit about your own background in this area, and then this opinion, and get to the whole issue of what reparations means in terms of Native American people in this country.
Great. So, when Gorsuch was nominated, I think I'm on the left, there was some nervousness, rightfully so. But among Indian community, there was some advocacy for him, despite him being a more conservative justice. And I think when we think about justices, I think of Sotomayor as the sort of quintessential, I'm going to be supportive of Indians, and has been. There was an early thing in her term when she first started being a justice where they looked at where she had voted and which group she had consistently favored, and it was Indians that had gotten that. Gorsuch, though, might be another one from the other side of the sort of political spectrum, where Indian country is expecting some positive things. And I think the reason, to put it in terms of sort of the last opinion that just came out, the law is often on the Indian side. So there, they, as the opinion said, though it's embarrassing for the rest of the country and the rest of the political branches that nothing's been done about this, Congress had not spoken to disestablish. And so the tribes had good reason to think that they had power.
And in terms of his judicial philosophy, he's been described as a textualist. He looks to the text, and that's very important in how he looked at this case. And I want to actually quote some of the language he uses, but he sort of says, the politics be damned, or the broad implications of my decision be damned. The text says what the text says.
Yes.
And it's not the place of a judge or even a Supreme Court justice to go against that text. If Congress wants to do something about it, and they haven't, that's the role of the legislative branch. So his sort of orthodoxy in terms of his judicial approach turns out to very much favor the Native American community generally, and the Indian communities in Oklahoma in particular in this case.
Yeah, I think one of the thoughts is, if only he had been around for, in the case that really strikes for me, is City of Sherrill, where the Supreme Court went the other way, and their only excuse for going the other way was a lot of time has passed. Therefore, the tribes have lost these abilities. But if you are a textualist, then maybe that case would have come out a different way as well. And I think everyone looking at this case, obviously the position Ted Cruz did in this tweet where he said half of Oklahoma is lost, next comes Manhattan, that's a ridiculous sort of fear tactic. But on the other hand, when you compare it with things like City of Sherrill, this might have longer legs. I think, we always have these cases come out and you wonder, are you going to teach it? This one is definitely going to get taught.
Yeah, and again, I highlighted this as one of my favorite parts of the opinion on the point that you just made, and what I was saying too, which is, yes, a lot of time has passed, and it very well may be that the city of Tulsa itself, with all of its industry and all of the population and all of that, has grown up on Indian land, which Justice Gorsuch acknowledges now as being Indian land. So what? And this is the part of the opinion I really liked. He says, how much easier it would be, after all, to let the state proceed, talking about Oklahoma here, to let the state proceed as it has always assumed it might. But just imagine what it would mean to indulge that path. A state exercises jurisdiction over Native Americans with such persistence that the practice seems normal. Indian landowners lose their titles by fraud or otherwise in sufficient volume that no one remembers whose land it once was. All this continues for long enough that a reservation that was once beyond doubt becomes questionable and then even far-fetched. Sprinkle in a few predictions here, some contestable commentary there, and the job is done. A reservation is disestablished. None of these moves would be permitted in any other area of statutory interpretation, and there's no reason why they should be permitted here. That would be the rule of the strong, not the rule of law.
Yeah. It's great. It's great stuff.
It's great stuff.
Yeah.
So,
Go ahead.
No, please.
Well, the only thing, when I think about it, and I think on the Oklahoma side, people are going to be nervous about this, but one of the things that I think the Indian community is going to do and needs to do is to highlight the fact that there are lots of times that Indians and non-Indians have lived together, and often it's been to the benefit of the non-Indians, especially in rural states where some of the drivers of economic growth have been tied to things happening on reservations. So, I think Oklahoma certainly is going to, as a state, and they're going to experience this as a loss. But I don't know that the people of Oklahoma are ultimately going to experience this as a loss.
Well, that is a point that Justice Gorsuch makes. He doesn't really set this up ultimately in terms of the tone he brings to the opinion, the way I read it, as an adversarial one. He talks about the comedy and the interconnectedness of these communities. Just a few weeks ago, actually, I drove almost the entire length of Oklahoma. I was driving cross country back from California, which is a whole other story. Yeah. And I wasn't really impressed that, you see signs now entering, whatever tribe's land you're coming into, but it doesn't feel separate. It feels very much integrated in many ways. The physical integration and other than road signs and some tourist souvenir shops and the like, it doesn't feel like a separation. It feels like it's pretty well integrated.
Yeah, I mean, I guess one of the things is that sometimes it doesn't, right? So the examples recently with the COVID checkpoints, right? So tribes putting up COVID checkpoints, and then one of the challenges is that from an Indian perspective, I'm not Indian, but from a perspective on Indian rights is that tribes sometimes want non-Indians to see that line as a little bit maybe more significant than that. So Matthew Fletcher, who's this professor at MSU, he said, maybe we should have like a sort of a border so that anyone that comes on knows they're consenting to Indian jurisdiction. We're not doing that now, but I think one of the challenges that this case does bring is that it has more significance than mere historical artifact.
And that's what I want to get to. And again, I'm grateful that we have this case that came out to kind of make even more timely and relevant this conversation. But tell us a little bit about yourself and how this became an area of interest to you, and some of the work that you've been doing on this.
Great. So I'm non-Indian. I grew up in small part. It's very careful. You have to be very careful about not over-claiming. In small part on the Navajo reservation. My father was a teacher. He remarried a Navajo woman. And then my mother is also a non-Indian, and she worked for the Navajo EPA and Navajo Superfund, basically Navajo environmental planning for her career. And so I grew up a little bit in Kayenta, which is probably most famous for being the site of the, the Back to the Future 3, where they run in, the car drives into the old West, and then Indians are coming at them. That was 20 miles north of Kayenta. And so I grew up near Kayenta, and I also grew up in Window Rock, which is the capital of the reservation. And then we moved, my dad moved to an area near Shiprock, which is very, very remote, Cove, Red Valley area. So I grew up in part on the reservation, and basically went to law school and undergrad and thought, once my career as a photographer failed, I thought, what could I do professionally? And I knew I cared about poor people. And I knew a little bit more about Indian stuff than the average white person. And so I thought that was a good path to go.
Right.
And so since then, I've written mainly about Navajo economic development because that's the tribe that I know the best. I did a couple other things with some other tribes, but it's been largely Navajo.
Yeah, I don't see photography in your background, Ezra. I see Yale undergrad,
Yes.
Harvard Law School, and a master's in philosophy from Cambridge.
Yes. So while I was at Yale, I tried my best to be a professional photographer, and then I discovered I'm just not good enough.
So this may seem like a really huge question, but if you can, where are we as a country in the way the law regards Native American people and their rights? I mean, are the big issues today what we see somewhat played out in this new Supreme Court opinion, that it's really about, which by the way, the case did not set out to declare that this was Indian land. It's really about whether state law or federal law applies in the prosecution of someone who was accused, an American Indian who was accused on Indian land of committing a major crime. And that's how this issue gets to the question of whose land is it, therefore which law applies. So it's actually on one level kind of a boring issue, not a very exciting issue of, you could say choice of law, as lawyers say, but it ends up having to tackle these much bigger questions to get at that issue, which is what makes it so interesting. So, but where are we as a country in terms of our law? I think many of us most days don't think about Native American people and their rights. Now we have this political movement that has, as I was saying in the outset, is not only refocusing people's attention on the long legacy, the long and terrible legacy of slavery, but folded into that conversation has been a renewed focus, at least what seems to be a renewed focus, on the long shadow of the terrible legacy of what was done to the Native Americans in this country. Is there a way to summarize how we regard that issue from, as a legal matter? Because the law has a lot to do with these issues. There are treaties, there are Supreme Court decisions.
I think that the long picture is actually we're in a pretty good spot relative to some of our horrible history, right? So it just depends and somewhat on whether you take a macro or micro focus. We are in the middle of the self-determination era and have been since Nixon, and that's been a very positive thing for tribes, that they have gotten more authority to do things, and over time they have taken on programs that have been formerly done by the BIA or by Indian Health Service. And that has been a net positive for sure. Normally in the law, we think of it as the two political branches largely supportive of that effort and the Supreme Court not supportive of that effort. And so there have been sort of this split between wanting self-determination from the president and from Congress, regardless of of their affiliations. So we can always find outliers, but generally speaking, Republicans and Democrats have both wanted self-determination for tribes. On the other hand, the Supreme Court, especially if it involves non-Indians, doing things to reject that, to limit the power of tribes. So I think you could tell a good story or a bad story. I think the larger societal, that's a little less law, but it's very easy for non-Indians to ignore the fact that they're on Indian land, right? No matter where you are, you're on Indian land. It was at one point Indian land. It might have been acquired in better ways or more fully than it was in Oklahoma, but it's Indian land. And so I think the challenge is until we're at a position where Indian harms are taken seriously, we're still in the position of largely ignoring many of their claims and their needs. So last examples I'd give is I think the Washington D.C. Football team, right, is getting attention now, especially this week because of Black Lives Matter.
Yeah.
But it's amazing that we still have to deal with this many, many years after it was brought up by tribal members saying this is wrong. And only when FedEx decides to pull funding and other advertisers start to pull the jerseys do we see Snyder actually respond. We're not with the claims that this is wrong.
You're right. I mean, we're seeing companies, football teams, maybe not the Chicago Blackhawks. I just read about why the Chicago Blackhawks are not going to change their name. And even consumer products that are, after many, many years, I mean, Aunt Jemima, done. That is gone.
Land O'Lakes.
I was just going to ask about Land O'Lakes, right? The butter with the caricature of American Indian on the packaging. So that's a societal, cultural phenomenon that we're seeing, an acceleration of change in some of those ways.
Yeah,
but, right. That's not so much the law responding. Maybe the law is lagging in some of these changes right now.
Well, certainly on the DC football team, they did, right? So there was an effort that the Supreme Court decided with the Slants case, which was about a rock band of Asian Americans. And they used that to then come out with a holding that would not go against the DC football team. And so because of that, there was not the law able to respond to the harms that were associated with it. But ultimately money mattered, right? That was what drove it. But I think of the larger picture is that we tend to ignore Indian harms, right? So the last example, and this is from, I love the 1619 project that the New York Times did. It's great. It has lots of great reporting by huge people, especially in the poverty law space. It's great. But there was slavery and mistreatment well before that. They were just directed at a different group of minorities rather than African Americans. And we often, just forget about the Indian side.
Well, and that brings us back to the whole question of whose land is it, right? Because this case that we started out talking about, what Justice Gorsuch is interpreting are treaties and the language of those treaties, and Congress's failure to act legislatively in any way that would alter the language of those treaties, where those treaties only go back to the 1830s. And then there's the reference that I quoted where he talks about Indian landowners losing title by fraud or by coercion or intimidation. But of course, you could wind back the clock even further and say, as you suggested, that all of the land in what we call the United States was Indian land. So how do we tie that into the conversation we're having today? Because I don't think we're going to see a recognition of property rights for Native Americans in the entire space of the United States any more than we're going to give back Texas to Mexico, although sometimes I think we should. I mean, land was taken by force. It was taken by conniving. It was taken by treaty. It was taken by purchase. I mean, what do we do with that, as Justice Gorsuch says, that very messy history?
Yeah, well, I think that we've actually tried this in the past. So there was an Indian Claims Commission, and one of the issues with the Indian Claims Commission process was it did not leave land restoration as a possible remedy. And so some tribes exited from that process when they realized the only thing on the table was money. There was no way to get their land back through that process. And I think we're still, in some ways, dealing with the repercussions of that choice, which was the legislation didn't require that. That was just a choice of the commission itself. But I think even if we don't think of it as the more extremes, at the very least, we could treat Indian property rights as having some legitimacy with some of the protections we normally have. So I think it's easy to look at someone like the case that just came out or the city of Sherrill and look back, it's hundreds of years ago. But the Supreme Court also did in Teton, a case about Alaska, just denied their property rights in ways that would never have happened if they were non-Indian. And so I think we routinely sort of treat Indian property rights as lesser, even when those rights are otherwise recognized. You know, I think even in the reservation context, there is issues about how that is managed and what the role of the BIA is and their involvement or lack of involvement.
Yeah, the Bureau of Indian Affairs.
Yeah, the Bureau of Indian Affairs on things like title searches. So things that would just never be tolerated off reservation. Tribal members have little choice but to tolerate there. And I think it just comes down to a choice. Do we care what happens to Indians? And for a long part, we've decided we don't care.
Well, and again, even in this case, the Oklahoma case that we were talking about, it's not like Justice Gorsuch is saying, this is your land and you have full autonomy over what happens on that land. The federal government still, and federal law still has the ability to come in and assert its authority, even on Indian land. You know, in the context of the conversation that is taking place right now over including the history of what really is a history of, you know, extermination and taking of land, and of some of the cases that you've mentioned of failing to recognize any rights or interest in that land. Where are we today then? Where do you see things moving forward? And does this opinion, for example, suggest any future direction in terms of how, as a country, as expressed through how our law is going to treat these types of issues, how we're going to regard Indian rights in their land and in their right to govern themselves, in their right to have rights while they, you know, continue to share this land with us?
Yeah, well, I think there's a couple answers. One is it's nice to see treaties taken this seriously, right? So one other one that got attention from Oklahoma that I was involved in as a law student was the Cherokees have a right to a congressional delegate under a treaty, the removal treaty. And we saw the Cherokee Nation appoint somebody to be their delegate. We haven't seen what would happen with that.
A delegate to
Congress. So there is the removal treaty says that the Cherokee shall have a right, shall be entitled to a delegate in the House, in the Congress, in the House.
I would love to see that. What happened to that?
So nothing happened for a very long time. And then just this last year, I think it was within 2019, early 2019, the chief of the Cherokee Nation, or principal chief, said, I'm appointing this person to be our delegate, but nothing's happened since then, right? So one of the questions would be what might happen with that. But I think stepping back from that, which I'm a little too invested in, we do see space for more treaty rights, I think. And tribes, you know, one of the critiques tribes always get is why didn't they assert these earlier? We saw this with sort of fishing rights in the Northwest. And I think the thing that's worth keeping in mind is for a very long time, we made it very hard for them to assert any rights, right? So one thing going forward might be more assertions of treaty rights. Another, sadly, on the other side is, you know, even this opinion says if Congress wants to, it can use its plenary power to just strip them, right? So there is always the danger of the plenary power being used aggressively against tribes. But I think on this case, and we do see it with this one, and we see it with the VAWA and with this other thing called TOLA, we're seeing a recognition that what is happening on the justice side is not working in Indian country. And there's been efforts recently to give back some authority, or it's technically not give back, it's to recognize inherent authority over some crimes that had been, and particularly crimes against women, that had been under prosecuted. And so I think there's space for, at least on the Indian law advocacy side, to push for more of that.
More autonomy in handling issues of justice and prosecution of crimes and prosecution of claims that involve their own people.
Yeah, mainly involving their own people. I mean, or other tribal members who are not, other Indians who are non-tribal members, of a different tribe. But places where there's a long history of seeing the under prosecution when there are these crimes. And sometimes in some of these laws, they're allowing tribal jurisdiction over crimes committed by non-Indians as well. But where we're recognizing that U.S. prosecutors are not interested in this, right? I joke that, prosecutors are interested in terrorism. They're interested in big RICO cases. Small level DV doesn't reach
domestic violence.
Yeah. And so that's something where you could see even non-Indians seeing the need to restore power or recognize power in tribes.
Interesting.
Yeah. And we're seeing it already.
And so what about other parts of the country where, as you alluded to earlier, some people may fear, and this is the slippery slope argument that we often hear in all kinds of different legal contexts. If you're going to recognize the language of these treaties with the Creek Nation, with the Creek people in Oklahoma, what about Manhattan? What about other parts of the country where there may also be these kinds of treaties that, if recognized, could lead to some at least putting some nervousness in the hearts of some people who, it's even a reference in the opinion that there's probably many people in Tulsa who didn't even know they were on Indian land. They never thought about it.
Yeah.
Do you see that as a potential, as something that could come from this opinion?
Well, I don't know from this opinion. I don't know if we as a society are ready to really take into account or think seriously about what we did with Indians and how we mistreated them. So I think it would be a stretch to think that, although I will say, the upstate New York one's great because in the Oneida case, they sent eviction notices to non-Indians living on the reservation as a way to gain, political power. And they thought in the negotiations it would force non-Indian governments to the table. It didn't work out the way they wanted to, but I do think it shows, there's more vulnerability there for non-Indians than they might ordinarily think about, right? Especially on the East. I think it's worth noting that there are some non-Indians, if you live near a reservation, where reservation and you are very closely intertwined, right? So there are, and I'm out here in DC, I get just stupid questions from people that are sort of reflecting a very dated understanding of Indians. But on the other hand, there are other non-Indians who live in and are part of the communities of those reservations. So they're very differently situated. I think when I did my work on the Oneida, the most entertaining interview that I read was this interview of somebody who was like, my family has been here for a very long amount of time. It's always been our land, right? And she was able to track back to exactly when they acquired the land. But for her, history stopped at that started at that moment. She wasn't able to go 1 year further back to see where it came from before that. Yeah.
So what about the issue of reparations then? I mean, because we are hearing more and more about that, as we should be in the context of reparations for slavery. I feel like we're also hearing more and more about that in the context of the violence in its many forms against the Native American people. What does reparations mean in the context of the Native American people's experience on this land?
Yeah, I mean, I think this is a hard question. I'm going to push back a little bit on it as far as the framing. My own thinking is that it would go a long way just for us to treat Indians as well as we treat non-Indians. So reparations usually has this idea, let's give this group that was harmed extra or special rights. But then we look at how we are actually tolerating, and in my case, I care about the poverty, the level of poverty we tolerate on a reservation, I just do not think we would tolerate anywhere else. And in fact, we don't, right? So when there is that level of poverty in other places, we dedicate more resources to it. We at least make some efforts. On reservations, we are fine with 50% unemployment. I mean, just think about what 50% unemployment would look like in non-Indian areas, right? So I would, and the same goes with our federal funding. We have federal funding, say, in IHS, and everyone talks about IHS as a special right that Indians have, but they're underfunded relative to the funding that I get as a non-Indian through the subsidy to my employer-based healthcare. So,
And IHS is Indian Health Service.
Sorry, yeah,
That's
Indian
okay.
Health Service.
I'm trying to figure out the acronyms, but yeah.
Sorry about that. So,
okay.
So I think it would be a start just to treat Indians as equal to non-Indians, much less reparations. I mean, on the reparations side, there are, of course, lots of reparations, and you could look, really far back for land issues, but there can be much more close ones, right? So some of the harms done in the boarding schools where kids were forced off, those people are still living. It's not like we have to find their descendants of the victims. The victims are still there. And so I, of course, think there's lots of space for reparations, but I would be content just to get us to treating Indians like we treat non-Indians. That would be a big improvement for the life and community in many reservations.
Well, it seems like the excuse for not doing that has been and to tell me if this is right or not, but they have their own nation. I mean, we talk about, the Navajo Nation or what have you. Is that right? That we really have looked upon the land that they have been left with as reservations, like they are reserved out of the system, out of sight, out of jurisdiction, out of being a people we have to care about.
Yeah. And I think that is fair as a response. I think the challenge.
I'm not saying that personally.
No. I think there is something to that. I think there is, and I've written about the responsibility tribes have when they make bad decisions, just like any government. They have to own it. But I think the two thoughts on it. One is sometimes we have programs that are designed for people, and we deliberately make them sort of inaccessible for people on reservations. And so Obama settled one of the suits. The Department of Agriculture. There were two big suits about agricultural programs. One was they were sued on their mistreatment of Black farmers, and they were also sued on their mistreatment of Native farmers. And Obama chose to settle both because there were problems with the way the programs were run and the way that they did not allow access to the same lending and support systems that non-Indian white farmers were able to get. So
settling meant what in those cases? Paying
money.
compensation?
Yeah, out of the judgment fund. So it meant money. But I think larger on this is that tribes are domestic dependent nations. It's one of the first characterizations Marshall gave of them. And they are fundamentally still part of us, even when they are independent sovereigns. And that conflict, right? Independence and part of us, is just inherent to what they are, right, as tribes. And I think a lot of people and some of the justices on the Supreme Court just are incapable of thinking both thoughts at the same time, right? Independence and domestic dependent. But once you start to take that seriously, as we, the United States, need to maybe adjust ourselves rather than they constantly adjust to us, then I think there is more space for recognizing obligations to those tribes just by virtue of them also being American citizens. So tribal members are tribal members, but they're also U.S. citizens. And I don't think we would tolerate, just to go to COVID thing, the COVID stuff happening on Navajo right now. If it was happening in, what's a white state? Iowa City.
Yeah. So, I have to say, I didn't even know that they were considered citizens as well as being citizens of their tribe.
Well, that was imposed upon them. So let's just note, this is a controversial thing.
Oh, I see.
So
what a good thing.
We declared it that they were citizens. And in fact, with the allotment, there was this period of time where we took reservations and we, without their agreement, split them into smaller sections. There was a whole process where people could sort of get their land more free if they released their Indianness. There was one ceremony where they shot their last arrow, right? So there's just this sort of grotesque Eurocentrism, even with the way that we gave or imposed citizenship.
Well, and one of the ideas of allotment, breaking up the land into smaller chunks, was actually, wasn't that actually a plan to hope that over some period of time, a generation or two, that land would be sold off to non-Indians, and in that way you would essentially finish the job of extinguishing the Indian population?
Yeah, and it
they
wasn't
would have
even
nowhere left to go.
And you didn't have to wait. I mean, the program was designed where they carved up the reservations according to the population of the tribe, and any surplus land was immediately made available to non-Indians. So it was really a land grab with some time delay for some of the land, but a major land grab that the Supreme Court upheld.
Well, and there's an interesting little passage in Justice Gorsuch's kind of recounting the parts of the history that he talks about, where there were actually those in Congress who were very skeptical of this move when it came to places like Oklahoma, because the people that wanted to go in actually and buy up that land were the oil interests, because they found oil in Oklahoma, among other people. And there were those who were nervous already then about the oil interests becoming too big and powerful. Today, it seems like it's more, when you think about what we should do with this history and with this legacy, it's, I don't know if the Japanese internment during World War II is a reference or a point to think about whether there's similarities, because there it really was just a horrible wrong, a violent wrong committed against a people, and then it ended, and almost a sense of responsibility of acknowledging that was a wrong, and that we had to do something to own responsibility for that, and not make it right, because you can't go back in time and undo what was done, but to compensate for the harm that was done. Apart from what you're saying about addressing issues of poverty and underemployment and ways in which Indians are not treated, as you say, the way any community anywhere else in the country would be treated, although we do have very severe pockets of poverty in other parts of the country.
We do.
Sure. In need of resources and attention and so on. Do you see in what is happening out in our politics and in the cultural, societal changes that we're seeing right now, do you see, even if it is more symbolic than actually compensating for, a move to greater ownership of responsibility for the violence done? And what might that look like, if so?
Yeah, I have a couple thoughts on that. First, I should say I teach a poverty law class too, so I'm very we focus.
I know I don't need to teach you about.
But I actually think on part of the challenges is that we are continuing to do some wrongs. And so I am not really that optimistic that we as non-Indians are going to do much. I think what makes me the most optimistic was the Standing Rock protest that happened. And that was crucially not led by non-Indians. That was, this is the protests about the pipeline that had a really big gathering. Those protests were tribally led protests, and they got stuff done. Now there was, pushback as the election happened, and Obama delayed a really long time ever coming out at all in favor. And then Trump, of course, immediately said, no, this is terrible, and went against. But that gives me the more hope. Another thing that gives me a lot of hope, there was, COVID hit Navajo very hard. It was one of the most hit in the United States. and the people that stood up were Navajo women through different charities, and the Irish who felt an obligation towards tribal members from past gifts from the Irish famine. But Navajo women really took the lead on getting systems in place to get support to their community. And so I get more hope from sort of internal to tribes than external. I think on the external, another example, and every tribe you can pick, you could think of something pretty recent where we as non-Indians are doing a wrong today, right? It's not just past ones. So the Navajo, again, that's the one tribe I know the best, but we did uranium mining, did not give them tools. We knew it was harmful, did not tell them the harm. And it was part of the development of the Cold War. And that looks then, oh, well, it's 50 years old. That's pretty bad, but it's not that bad because it's a little dated. It's pretty bad, but it looks old even now. Right?
Yeah.
People won't have been born. But then within the last 10, we've decided we're going to spray sewage effluent on a sacred mountain, snowball, sacred to the tribe. We would never do that on a non-Indian church. And so I think it's... I don't have a lot of faith in non-Indians on this. I have a lot more faith on the tribal members.
So, and when you say it, you mean being more emboldened by some of the successes that we've seen, despite all of the wrongs and long history of the tragedy in the history, but emboldened in some of the examples you're giving, and that pipeline that is now dead. So, yeah. I mean, that's a real victory.
It is.
So when you say emboldened, you mean emboldened by those types of things to assert even more, if not autonomy, and autonomy is part of it, but also to assert their interests and concern and wishes to have their history and culture respected, and not to have non-whites trample on those.
Yeah, I mean, I think
ways like the pipeline threatened to do.
Yeah, it depends on your perspective on the law, but I often see the law as sort of a following indicator, not the leading indicator of a lot of social change. So, on the Indian self-determination, you can tell that story as a series of things that began with Nixon giving a speech and got the series of acts that Congress approved. Or I think you can also tell it, and this is the way Charles Wilkinson did in this great book, Blood Struggle, where the best story he had was a tribal leader who was aware that there was this unfair lease for timber, and he put a chain and put himself in front of the trucks, and he led the sort of change that happened that dramatically improved the governance of that resource, this forest, and got better deals for the tribe. And so I think we could tell it as a law story, but I think what we see is that when Indians leaders and people just assert themselves, often the law will follow in recognition of that success. And that's what I see Standing Rock as. It was just a really monumental thing that people would drive from all over the country to go be part of that.
Mm-hmm. Where do you see, I mean, often into the distance over the next few years, what is the next Standing Rock, do you think?
That's a good question. I have no clue. I think there are, one of the things that's made Standing Rock a little easier within the Indian community was that the leadership of the particularly affected tribe was also on the side of the protesters, right, and against the pipeline. I think intertribal disputes could be something similar, where a somewhat captured by outside interest or just monetary capture of some group leads to a protest by members against that, and that it inspires other groups, other tribal members and other groups to join. I think that will be a particularly hard battle, because then it's sort of sovereignty versus internal, just like we have with BLM, Black Lives Matter versus the state, right? Mm-hmm. So I think we will see some of those, but I have no clue which will galvanize in the same way.
Interesting. We'll have to keep an eye on that for
yes.
Fascinating and a great. We'll put a link to this opinion. There are definitely some opinions you read and you start to wonder how you're going to stay awake. But this one actually is a really good read with a lot of good history in it. And for those who think you understood this justice because he was appointed by President Trump, there's some real surprises in it, and very readable. I think I really encourage people to take a look at it. We will put a link to that in the description for this episode. We'll put your bio in the description as well, Ezra, so people can find out more about the work you're doing. When is your book coming out?
I don't know. It's with outside reviewers now, and we will find out. I finished. I had a sabbatical, and so I finally finished. This is a book that's been on the back burner for just way too long. I kept writing anything poverty related until my father one time, he said, "Oh, just like the other non-Indians, you're ignoring the Indian stuff." And I was like, I better finish my book. Oh
my God.
Your parents can put that sort of pressure. And so I finally finished it. And at some point it'll come out. And the trouble with an academic work of any sort is you never really know who's paying attention, but hopefully somebody reads it.
Well, we're not paying attention, so
thank you.
Thanks so much for being on Good Law, Bad Law. Ezra Rosser from the Washington College of Law at American University, and we will keep an eye out for his book on Navajo land and economic development, exploiting the fifth world. Thank you so much.
Thank you so much. Definitely. Thank you.
Great.
Bye.